Good afternoon. Welcome to our fifth and final Idea to Impact Forum here for the 2015-16 year. We're grateful to have you here and grateful to have our panel here who's going to have a very engaging conversation about intellectual property protection. Now, I see a lot of new faces here today, and I'm thrilled to have you here. I thought it might be helpful if I just give you a little bit of a schema on what we've covered so far this year in our previous Idea to Impact forums. In our first session, we talked about the innovation process, and is it something we should even be doing here at ECU? And the answer was a resounding yes. We heard from at the highest level from the provost and vice chancellor that innovation and ideation are activities that we should be engaging in here at ECU, not only for the benefit for us as individuals in our institution, but also for our region and our state. Our second session, we focused on an sort of an evaluation process, if you will, and if I have an idea or if you have an idea, what do you do with it? Many times people think I should run right out and get a patent or start making money. And really, there's a lot of work that needs to be done. So we talked about some of the things you ought to be thinking about to fully assess your idea for its merits. We also talked about you might need to get some advice from skilled advisors to kind of tell you, is your idea have merit, or perhaps you need to advance it in some manner. And sometimes our advisors will be really honest and tell you, your baby's ugly. And maybe you should look at something else. So these are some things that we talked about in our first couple sessions. Our last session, we talked about funding. If you have an idea, it's going to take some money, some cash, some capital to advance it in some manner. And we talked about different forms of capital and where you might go to look for that capital. We talked about grants. We talked about angel investors. We learned for some people it may be a new term, bootstrapping. How do we do this on our own with our own resources? We learned about venture capital. And we learned about grants that are available both through the institution or to small businesses. So what's the logical progression of this is now that we have something, maybe an idea or something that we have some merit, and what do we do with it in terms of protecting it? Because many times people are actively telling people about their ideas, but perhaps there's a way that we can protect the idea so we can kind of have some ownership to it and not give it away. So to promote that conversation, we've got an outstanding panel, I think you'll really agree with me once you hear them talk, of some skilled people who've been in the field working in this. So to facilitate our conversation today, we have Carlisle Rogers, who is our licensing associate with the Office of Technology Transfer. Following Carlisle, we have Alice Bonin, who is with the patent law firm Myers-Beagle, which is located in Raleigh. Following Alice, we have Will Cannon, also an attorney with the firm Parker Poe in Raleigh, and Will's expertise is in copyright and trademark, and he actually manages ECU's trademark portfolio. And to round out our conversation, I've got a good friend and someone I know who will be very lively in the conversation, and that is Lee Workman, who's Associate Director of Athletics here at ECU, and his charge, among many things, is ECU's trademarks, athletic marks. Now, in your brochure on your tables, there's a brief write-up about each of these individuals, so I won't go into more detail about them, but you can read about them in your brochure. Before I turn the program over to Carlisle, I just wanted to mention, what the format of today's program is going to be like, since we have so many new people. It's the first 30 minutes is basically going to be conversational, fireside chat among Carlisle and our panelists, our guest panelists. Following that, we'll have a period of Q&A, but because our program is being filmed, what I'd ask you to do is to make notes or write down questions on the little index cards you have on the table in front of you. We've provided pencils for you. Write down those questions, and when it's time for Q&A, I'll ask you to pass your questions on to one of our staff members. We've got Diana Wright back in this corner, and Lucretia Davis is sitting out in the hallway right now, but she'll be back on this side. And they will pass those questions on to me, and I'll read them on the mic so we can pose the questions to the panelists. Following our Q&A, I hope that you'll stick around if you're able to, because we're going to do some table exercises, some small discussions at each of the tables on different forms of intellectual property protection. So it'll give you a chance to kind of test what skills you have in that. So that's a bit of what the format will be today. I think probably I've spoken long enough, so what I'm going to do is turn the program over to Carlisle, and I'm sure you'll have an engaging conversation with our panelists. Thank you, Carlisle.
Thank you, Marty. So, what is intellectual property protection? I would say that for most of us, if we know it or not, we have intellectual property protection around us each and every day, whether it be our coffee mug that may have a trademark on it, the book on our desk which has copyright, or the cell phone which has numerous patents. The goal of today's panel is really to unmask what intellectual property protection is and bring it out of the shadows so we can figure out how it can benefit us and exactly what it is. And with that, I'd like to start the question with Alice. What exactly is a patent?
What a patent does is it allows you the right to exclude others from practicing whatever invention you get patented, whatever gets granted. That means that you don't necessarily have the right to practice that patent. And that's because you can end up patenting and many patents are like this, they're improvements on a prior patent. And so an improvement means that you then, you may get that granted patent, but then you have to get rights to the underlying technology that you've improved on. So that's why patent rights are considered an exclusory right, not so much, the ability to use it. And an example would be, for instance, is a second use a patent on a medical second use. So you have a compound that somebody else may have a patent on, and you've come up with a novel and non-obvious idea or method of treatment using that compound. And while you can get a patent on that method of treatment using that compound, you can't actually practice that method because you will have to get, as long as there's a patent existing on that compound, you'll have to get rights to use that compound. That's just a simple example of what can happen. There are different types of patents. Of course, I think many people are familiar with the design patents, and those cover things like in fact, much of what the Apple-Samsung war is over are design patents. So they can be quite powerful. And then you have utility patents, which cover the function, not so much the look. A design patent is the look. And there are plant patents, which cover plants. And there's other ways to get protection for plants besides patents. And I think that's it.
So in terms of length of time, is it forever? Is it for 20 years, 30 years?
So a utility patent, which most people are familiar with, has a 20-year life from the earliest filing date. So that means that if you put your stake in the ground early in what they call a provisional patent, so you have 1 year to finish really doing what you want to do, experiments and really tightening up your patent application, then it starts. That actually doesn't count, that first year, but it's from the actual examined application or from another type of patent application called a international application. So you have 20 years from the date that was filed.
Okay. Now, in terms of cost, is this something you can spend a few bucks on, or is it something you really need some capital?
You really need capital. I mean, you can file what they call a quick and dirty application for, several $100s. You'll see advertisements from, I can't remember what is the company that advertises online for doing.
Like a LegalZoom?
Yeah, LegalZoom.
Something like
LegalZoom
that.
will do it for you. But the problem with that is that you only have the rights that are in that document. And so if you don't have it fully fleshed out, it could be, number one, easy to reverse engineer, design around. You really need to have some expertise in developing that patent application. And those generally run depending on the invention, and I'm talking about a utility, $5,000 to $10,000. And then you're not even talking about, say, if you go worldwide, you're talking about hundreds of thousands of dollars by the time you're done just filing them. Then you have to worry about maintaining them, their fees to maintain them.
So Will, is copyright similar to patents, or is it different?
So it's similar in that once you obtain copyright rights in a work, you can exclude other people from copying, from creating derivative works, from using your work. But it's also different. So what is a copyright, like 101? It is when you have a creative work that you fix in some tangible medium. So if you write a book, if you write a song, if you write software code, what is it not? So if I give this conversation, there's no copyright in that because it's not fixed in a work. And if I play tic-tac-toe with my kids, the tic-tac-toe board, there's no creative element of that. So that's not copyrightable. So it's creative and it's fixed. You obtain copyrights, and this is an interesting difference, an important one from patent rights, just by fixing your work in this tangible form, your copyright accrues. So you don't have to go to the Copyright Office, and in fact, you'd be shocked at how few of my clients do file copyright applications because you own a copyright in your work just by creating it and fixing it in a tangible medium. So why would anybody file in the Copyright Office? If you file in the Copyright Office, you obtain some statutory remedies. When the kids were getting sued for Napster, they were relying on these statutory remedies where they could threaten the maximum penalty of $750 per song times 1,000 songs. That becomes a really big number. So if you want to have access to that kind of a stick, you might want to file for copyright protection. But if you're not going to be enforcing your right, the process of filling out the form, submitting it, obtaining the registration, often is not worth your time. It's cheap to do, though, so if you are thinking long-term, and let's say you have a book, surely you'll file the copyright for that. Software code, maybe, but one issue you want to think about with software code is if you file a copyright application, you have to submit the source code. And that's the holy grail of your trade secret and your information. And so that's often a disincentive on the software side to file the application. So you can always talk to an attorney if you have a work and you're wondering whether or not to file. Sometimes it's a little bit of a calculation.
Now, in terms of cost, is that similar to a patent? Cheaper, more expensive?
Much cheaper. The filing fee is, $50 or less to file the application, and it should take less than an hour of attorney's time. So, I mean, you can fairly cheaply get that application filed.
Now, in terms of time, are we limited by 20 years like we are with patents?
No, much longer. So it depends in part on the type of the copyright application, but they can extend 75 or 99 years. Basically, if you file the application, you're probably protected for the rest of your life.
Excellent. Now, switching gears, Lee, you sort of do the opposite of these guys. Your job is to sort of protect that mark and police it. Mm-hmm. How much effort's involved in that?
Well, for trademark protection, it really depends. If you're looking at the first piece of it would just be filing for registration to protect your mark, which Will does for our university here as our outside counsel. And there's a process with that, there's a cost with that, and that's the first piece of it. The next piece of it is really, once you get that trademark, it's monitoring it. And it's, whether somebody else is wanting to get a trademark similar to yours and they've filed to do the same thing, or if it's somebody out in the community that you've got to protect what you're doing with their uses of the mark. And so from a trademarking perspective, that's really the protection pieces of that. And then once you have your mark, the last piece of that probably would be that I would say in a protection mode would be when people are applying to use your mark. In our case, our trademarks that we have at the university, whether it's, if you look behind us, is the name of the university, East Carolina University, is a trademark. The graphics that go along with that are a trademark. Colors are implemented into that trademark and can be protected. So the next part of it is somebody wants to take and use your mark, create income from that mark, or somebody internally wants to use that mark in a promotional way of making sure that everything's done appropriately at that time.
Excellent.
Can I jump in real quick, Carl?
Sure.
So just to provide a what is a trademark, it's a brand. It's something that links a product or a service to the person who produces it. And so consumers are able to look at a brand. Like if I see something from Apple, because I'm familiar with the Apple brand, I may not have ever picked up an iWatch, but I have certain ideas about its quality, its level of sophistication, its durability, and that's because of the trademark. And so it can be either a word or a design like the Nike swoosh, or a phrase like just do it. It can even be a color like brown for UPS, or there's a brand of women's shoes that has the color red on the bottom. I don't know what that is, but that red is a trademark. So all sorts of things that if a customer sees something and it immediately looks and thinks of your company, that's a trademark. East Carolina University is a mark, but so the title of a book is a mark, but the book itself is a copyright. I'm trying to think of where the intersection is.
Right.
So Moby Dick would be trademark. The book itself will be copyright.
Now, in terms of cost, Will, is that similar in terms of copyright?
Yeah, so there's two types of trademark applications. You can file an intent to use application or an actual use application. An intent to use, you're saying to the trademark office, look, we are taking affirmative steps to get this mark launched, but it's just not out in the public yet, and we're going to do it in the next 3 years. To get an application prepared and filed in a single class is about $1,000. If you're filing an actual use application, it's probably about $2,000 because you've got to submit specimens to the trademark office that verify what it is that you're doing and when you started doing it. If you file the intent to use application, you've later got to file some additional documents that prove use. So you're looking at a couple $1,000s all in, give or take.
Okay, interesting. Now, Lee, you mentioned people can come and work with the university, use their mark. Could you sort of go over that approval process?
Sure, we can. Now, but from all these initial questions and answers, you understand why there's two attorneys here and then there's me. All right. So you heard the technical, and they know the answers. And then what Will does is keeps me from doing it wrong once we have to apply it on our campus. So, and then we got Paul Zigas. See, that's not good enough to have these two here. They've got Paul Zigas here,
right,
who is our on-campus university attorney, to make sure I don't mess up today too. So, on our campus, we actually have 3 different approval processes, if you will. If you're a department, a student group, a student organization, if you're somewhat connected any way with our university, and you want to use, it's orientation and you want to hand out things to promote the College of Business. Well, you want to get a product made to do that. Well, we have 350 licensed manufacturers, producers, that can produce East Carolina products with our names, our marks, our graphics on them. And so you would go to one of those companies, obviously, to produce it. You're required to do that. But we have an on-campus system called Logo Review. And it's online where you submit the information. Here's what I want to produce. Here's what I want to have on it. Here's who's going to produce it. Here's how many we're going to do. And we work real collaboratively and real closely with Clint Bailey and Brent Birch with our University Marketing and Publications Office. And so anything from the university that's what we term as an internal consumption item, something that's not going to be resold, something that's going to be used by the university or some organization or department to promote the university, goes through that system. And there's no royalties paid on that or anything like that. It's a internal consumption use. The second piece of getting approvals, and I'll just jump into this real quick for you, is when you go to the Dowdy Student Store and you're going to buy something with East Carolina on it, a lapel pin, a shirt, it really doesn't matter what that is. Those 350 licensees that the university has approved to do that, they will submit every design that they ever come up with that we have to approve as a university before it ever gets to the market, before it ever gets to retail. And so working with our licensing agency, the Collegiate Licensing Company, then we work with it from that perspective there, and there's an online electronic way to do that. And so we will see in our office working through, not counting the on-campus now, just for resale, those companies are out there that want to use our marks in some fashion or form. We saw the last 12 months over 5,200 submissions.
Wow.
And so we'll see things like that, and that's just normal. That's a normal year for what we will see.
Wow, that is excellent. Now, switching gears, what's the criteria for getting intellectual property protection? Can I just go out and file a patent and I'm good to go?
For a utility patent, which is the typical one most people file, you have to meet certain criteria. So, and that's really what we're talking about is patentability. So you can file anything you want, but if you want to get somewhere with it, you need to meet some threshold requirements, and one being is subject matter eligibility. So there are certain categories that you can file under. One is a composition, one is a method of manufacturing or producing, and these have in the past been very broadly construed. So there was a phrase many years ago, anything under the sun is patentable, but in the last 5 years in particular, that has been wound down and narrowed considerably. And I don't know if you want to talk about that now or later, but so that's a threshold issue that you need to talk with whoever you're getting advised with or taking advice from as to whether your particular invention would meet the subject matter eligibility. The other one that is a threshold question is utility. Everything, that's a pretty low bar. Pretty much anything you could make an argument for utility. And then you have to have novelty and what they call novelty and non-obviousness. Novelty is whether it's new and unknown, and non-obviousness is whether someone skilled in the, normally they use the word ordinary skill in the art, having that ability, could look at what's already been done and come up with your invention. That would be obviousness. So novelty, somebody has to have done exactly what you're trying to claim. And obviousness is sort of a coming together of a lot of different, what they call prior art.
Now, Will, are we playing by the same set of rules, or are there a different set of rules for trademark and copyright?
Yeah, so copyright, there's no level of scrutiny, right? You know, what's that book, 50 Shades of Grey? Like, that may not be great literature, but it's easy to get a copyright on it. No one's going to look at it and say, this isn't good enough. So long as it's sufficiently creative, you can obtain the copyright. Of course, you can't be copying someone else's existing work, and to the extent that it is duplicative, then you risk an infringement suit. But the bar is lower. If you submit something and it's reasonably creative, you're likely to get the copyright protection. On the trademark side, it's a. You want to?
Go ahead.
All right. It's similar. The thing you have to worry about on the trademark side is whether somebody else is already using that brand, and if your trademark application covers a mark that's too similar to an existing application, it'll get refused. Another thing you need to think about on the trademark side is whether it is sufficiently strong enough to be a trademark. And so trademarks have a spectrum of strength. On one side, the strongest trademarks are created words like Exxon or Kodak that have no meaning until this company creates it and then fills it up with its goodwill in the consumer's mind. So like a completely fanciful mark. The next lower on the ranking is a word that's a word in the English language, but it doesn't have anything to do with the product. So you think about Apple for for computers. Those weren't linked in any way until Apple launched it. Next on the list is a suggestive mark, which gives a hint to the consumer about what the product is, but it doesn't outright describe it. And so copper tone for sunscreen, you think that tells you what it is, but it doesn't outright describe it. And then you move down towards descriptive and generic. I was dealing with an office action this morning for my client, South Carolina Federal Credit Union. And they are a federal credit union in South Carolina. And so we're having some issues getting that registered because it's just such a weak mark. So to all of you who are thinking up new brands, if you want to have an easier time registering it and a much easier time enforcing it, you want to have more strength to the mark.
Now, Lee, how important is protecting your brand once you get that trademark or copyright?
Well, they don't call our office the logo cops for nothing. It's very important because your brand is who you are. And so you have to protect that. If you don't protect, and the law actually requires that you protect it. And so if you have a trademark, you're required by law to protect it. So that's your first step to it. The second piece of that in my mind is if you don't protect it, you're going to lose your rights to it. So now, if we don't protect East Carolina University, to use our university as an example, and we don't enforce when somebody's not using it the way we want to, or we don't control how it is being used, and then all of a sudden somebody decides to use it in such a way that we don't think represents our university well, then we don't have the ability to go control that. And so if you get a letter from a brand owner, a trademark owner, East Carolina, whether it's us or whoever, they're not trying to pick on you. They're not trying to pick on the little guy. I mean, that's really when we have those situations, somebody will want to go, oh, the big university's just trying to pick on so-and-so. Well, trust me, the last thing we want to do is to do that. But we have to do that by law to protect the university. And so that's really what it comes down to at the end, is we're required to do that. And we have to do that or we lose the ability to do what we need to do. And certainly I don't think, everybody in this room that's associated with East Carolina University, to use it, to bring it personally to all of us, as a student, as a faculty member, as a staff member, there's value in the name East Carolina University. When you go out to get a job when you graduate, you're competing against other individuals from other universities. You want to be able to, when they say East Carolina, there's a lot of brand value in that for you. And so if you're a faculty member and you're doing something, it's a dissertation or research, or you're putting a paper out there, and when it says East Carolina University, there's brand value to that. And we want to make sure that that brand value is high to help everyone that's associated with the university. And that's why it's so important to protect our brand.
It's interesting. It sounds like ECU is a very strong mark versus some of your clients may not be as strong. So is all IP created equal? So if you have patent A, is it as strong as patent B, or what are the differences?
Well, in patents, there's a world of difference. I mean, one of the things I was talking with a client this morning about that's unfortunate about so patent law can evolve over time, for instance, and with what I was just talking about with subject matter eligibility, patent law has now, under the several Supreme Court decisions, which some people may be aware of, there's popularly known as the Myriad decision, the Prometheus or Mayo decision, and actually one they call Alice, which gives me great heartburn. But and it's made, for instance, software. Even though you may have a patent now, the software is not. Many software patents are now not enforceable. I mean, you would be crazy to try and enforce them under the atmosphere that's out there now. And I had a client I talked to about another type of biological product patent that I think is now unfortunately unenforceable. But a patent, if you're just looking at patent A and patent B, you're comparing different patents. I mean, what's going to make a difference is what kind of guidance you get. So you can get a patent to a very, very specific product, a very, very specific narrow area. And that may be enforceable, but the problem is that if you don't build around it a bit more, you can have people actually what they call design around it, or, well, that's the biggest problem. So usually what we try to do is add some breadth to the claim. It may not, we want it to encompass your commercial product, but we don't want it to be so close that somebody can come in and say, well, all I have to do is, leave this little bit out, and then I can, and it may not be as good as what you produce, but you can maybe do it cheaper because you haven't got the R&D in it, and all of that, so you can produce this product that may get the, cut away from what you actually have. So that's the kind of thing, is, versus narrow versus broad.
Now, can you get in trouble with trademark in terms of scalability?
How do you mean?
Well, let's say if I want to do the Greenville Yacht Club, for example, and 5 years down the road I want to grow that to a national brand.
Right.
Could I potentially run into trouble?
Yeah, that's a good question. So the way the trademark law works is that you have rights initially in the geographic area where you're using your mark. So before you file a trademark application, just you hang out a shingle, you're the Greenville Yacht Club, and you have rights in that geographic area regardless of filing. So if somebody opened up next door to you with that same mark, you could shut them down. But by the same token, if someone out in Seattle becomes the Greenville Yacht Club, if you haven't filed a federal application, you can't stop them. So why do you file a federal trademark application? It's so you get constructive nationwide rights in your mark. Greenville Yacht Club, sort of a weak mark, so you may have trouble getting that. But I mean, that's really where someone like Lee is totally invaluable. East Carolina University, in and of itself, that's a really weak trademark. I mean, this is the university in Eastern North Carolina. It's only through Lee's efforts that you police the brand and maintain its integrity. And so I represent NC State. We went after another college that was they wanted to be the Wolf Pack, and we have to shut them down. And there was some bad press around that, but Lee's exactly right. It's naked licensing. My wife is from Connecticut, and I'm from Eastern North Carolina, and she says I say that word wrong. It's naked licensing if you don't police your rights.
Yeah. And we're really fortunate, and now I'm going to kind of go at it from an athletics perspective for just a moment, which again is the front porch of the university. It gives us a very we have a responsibility and a privilege in that, being in athletics, of what we do as the front porch of athletics. But we're fortunate in that in the Division I NCAA athletics, in the FBS football division, we are one of, we're one of 3 schools that have the colors purple and gold. So we have some distinctiveness there that we can then roll over into everything else that we're doing. We are also the only school in the FBS level that are the Pirates. So it gives us another distinctive piece there. And then as East Carolina University, we're the only school that has the acronym ECU. So we have three real distinctive elements where we can come from as a university when we use athletics that can spill over to everything else of the university that comes back to trademark protection. And there's really 3 elements of what we do in trademark licensing: brand management, brand marketing, and brand protection. And so this protection piece is just one element of what makes it all work.
It's interesting comments from both patent and trademark and copyright. It sounds like you really have to put together a strategy moving forward to make sure you come up with the best, strongest protection. So I see that we're out of time. I want to ask you each, what are some key facts for university faculty, staff, and students they should sort of consider when they deal with patents, trademark, or copyright?
I think in terms of universities, I think one of the issues that we run into most frequently is late disclosure. And so if I had to say anything, I would say, when you have something you think may be patentable, go talk to your tech transfer people and let them know. They can do an analysis. Maybe you come back later with more developed, more experimental information that you need to actually put it together. But don't wait until suddenly you think, oh yeah, this is a great invention, but I'm going to give a talk on Saturday. So that just limits the ability of whoever is going to write that patent to get really the full disclosure, and it makes it very difficult. Makes it difficult for your tech transfer office to get it through the system in time to get it out to a patent attorney, that sort of thing. So that would be the thing I would say is in terms of universities.
Will? On the trademark side, I would say spend some time before you launch your brand determining whether that mark is available, because I have a lot of clients who come to me and they've spent a bunch of money. Even if they haven't launched their products, they've got letterhead, they've got packaging, they've spent all this money, and they're starting Apple computers, and I have to say to them, you can't do that. They've wasted their money. So the earlier you can evaluate that, it's a little more expensive in the short term, but in the long run, you'll save a lot of money.
And that was basically what I'll go to a second takeaway,
Yeah.
but my first one was is that it can get real expensive if you've gone down the road and then you find out you got to turn around and go the other way for what you've already spent. But if you get down the road and then all of a sudden that other trademark owner decides that they're going to file against you, now you've got legal fees and you've got a lot of things there. So it's a lot better for you financially to make sure you go up front, which ties into my second takeaway. Before you do something, ask. Reach out and find out and get an inquiry. And when I say reach out and ask, don't reach out and ask your buddy next to you or somebody that doesn't have knowledge of it. In our case, reach out to if you're on our campus, reach out to us in our office. If you're, our licensing agency, the Collegiate Licensing Company, reach out to them. Reach out to somebody that you can get a good answer from. Don't make assumptions, because most likely you're going to make a wrong assumption. And I would ask early and often if you're going to get into where you may get from a patent, a copyright, or even a trademark.
Great discussion. Let's thank our panel for being here today. I have to admit that I've never seen so many questions come up that we've been handed off, so I'm going to try to scoot right through them. And they come from a diverse group. This one here, from the position of an artist, excuse me, what's the quickest and cheapest way to protect our artwork, photographs, cartoons, and original works of art?
Well, the beauty is that you don't really have to do anything. Just by producing it, you own the copyright in it. If you want to file a copyright application, you can do that yourself. It's not like what Alice is up to, which I don't understand, right? Like, you can go to the Copyright Office and fill out the form, upload a copy of your picture or a script or whatever art you're doing, and you can do that yourself. You pay the fee with your credit card. So if you decide you want copyright protection in particular works, you can do that. But I would say to you, is that necessary? How concerned are you with someone ripping off your particular piece of art? And if you're not that concerned at this time, I'd save your $75.
Alice, I have a good one here for you. Plant patents. How can you patent life?
Yeah. So plant patents are directed at plants that breeders have developed. And they're not, so far, we haven't had any trouble with the issues of subject matter eligibility. I think because they are manipulated by man. Now, you can't go out into the woods and dig up a plant and come in and try and patent it. That won't work. You have to put in the hours and the years that it takes to develop these. And I actually work in that. I do work for a number of universities and individuals, and some of it can take 10 to 15 years to develop. So, and actually you can get a plant patent, you can get a plant variety protection certificate, and you can get a regular utility application on a plant, depending on what it is. But you can't patent a gene. It's a joke, sorry.
Let's shift to software. Patented software tends to be more difficult to get compared to an invention. Copyright reveals the source code. So is there some sort of an in-between solution for managing software?
I don't do software, my background's by tech, but if somebody asked me that question, I'd say your best bet is to try and keep it a trade secret. But the problem is, of course, is that trade secret doesn't protect you from reverse engineering. And so that would be my answer, but that is the downside, is that if there's any possibility of reverse engineering it, it becomes susceptible.
Yeah, that's great. I mean, when tech companies come to me to ask whether they should pursue patents, this is a great and tricky question. I think that if you're a shoulder doctor and you see an injury, you might always think it's a shoulder. So I tend to like the idea of not pursuing a patent for software because I think there are enforceability issues with that, but you are giving up rights. And so what is a trade secret? If you have commercially valuable information that you take reasonable steps to protect, you can prevent people from taking that from you. And sometimes it makes sense to keep something a trade secret. The classic example is the recipe for Coca-Cola. Mm. So that's a trade secret. If someone had filed a patent on that recipe or filed it in the Copyright Office, that would have long expired. But because it's a trade secret and because they take steps to protect it, they can protect it indefinitely. So that's the same advice I give, is if you want us to do a copyright filing, there's ways to redact information and try to make it as to reduce the damage as much as possible in terms of exposing the source code. But in general, I just say protect your source code.
Right, and the engineers in our firm do have ways that they're trying to deal with the current atmosphere in terms of software patenting, but it's still a very much an uphill battle.
Let's shift to a trademark question. Lee, here's a good one for you. How do you decide what is using a trademark well? Is that somewhat subjective?
Yes. What is using a trademark well? It comes down, I think it was something we talked about a little bit earlier. It depends on what you're trying to accomplish and what you're trying to achieve. What kind of brand are you trying to create? What kind of brand recognition or brand quality are you trying to create, and where are you trying to create it? And so I don't think there's one answer to that. I think it depends on, I think consistency. I think that's the word I would like to use, I think, as much as anything in whatever you choose to do. For a sustainable brand to create long-term value, to be recognizable, to build loyalty to build trust in, it has to be used consistently if it's going to be sustainable. And I think if you just look around at franchising and you look at all the different franchises, no matter what community that you go to and you drive up to a certain business that's a franchise, it's the same thing every city that you're in. So therefore, you've built up some type of brand loyalty, brand expectation, brand trust, that when you drive into that business, you know what you're going to get. Same thing from a university's perspective or any organization's perspective. That consistency that you use will give you the opportunity to have a sustainable quality brand.
That's interesting. I just returned from a trip to the Middle East, and it was very clear when I went into a McDonald's, a Kentucky Fried Chicken, a Pizza Hut, where I was going and what I was going to get when I left there. So that consistency is important.
And one other related point is the length of time you're going to use the mark. That's related to the consistency, but I represent a lot of breweries, and some of them will have seasonal beers, and they'll have a name for their winter. It'll be their snowshoe draft, but it's only going to be out there for 4 months, and then it's going to go away, and it may or may not come back. And so you want something with durability if you're going to invest the time. Otherwise, just don't worry about filing a trademark application.
Correct.
The questions keep coming in, so I'm going to try to see how many more I can get in here. I have heard that to begin the protection process, that you can take your idea and mail it to yourself. Is there any truth to that?
Are you talking about patent protection?
Possibly, or does it apply to any other form of protection?
I mean, I wouldn't count on it. I mean, I've never. I mean, you can't get, under the new rules, the AIA rules, it's not something I've ever thought about. There may be something to be said for, But you see, it's not a public disclosure. Yeah, I don't think you'd have anything to gain by doing that in patent law.
So AIA is the American
Yeah, sorry, the
Invents
American
Act.
Invents Act, which was instituted in 2000, in bits, but 2012, 2013, and changed the way that public disclosures and things like that are viewed, and what is considered to be what they call prior art, which is the sort of thing that can knock you out in terms of patentability. That's what the patent office looks to. But I don't think that would help you much in confidentiality agreements. Those kind of things are better. You're better off working on something like that if you're going to talk to somebody about it.
I've seen people use provisional patent applications as effectively mailing it to yourself, where the application can be hot garbage a lot of the time, but they just want to get something on paper.
So you're saying that they prepare what they call a provisional application, they send it to themselves?
So no, but I'm saying they get it on file just to have
Oh.
some sort of public.
Oh, no, that's absolutely true.
Date in the sand.
If you want to put a date in the sand and you don't care how in-depth it is, yeah, you can do that, but mailing it to yourself, I don't see that as giving you much.
That may have been back before the pre-AIA days, where it was in the U.S. first to file, versus now it's first inventor to.
Well, no, it used to be first to invent, and you
Right.
could challenge somebody in the patent office even if they were first to file, if you could date back to being the first to invent. But I still don't see how mailing it to you is going to help you there. It all relates to public disclosures and getting your patent application and your stake in the ground, whether it be with a provisional and a quick and dirty idea into the patent office. But
I have another trademark question for Will and Lee.
Yep.
How do you enforce colors on trademarks? What makes one shade of purple something that you can watch over versus another?
You want to go first on that one?
Yeah, so anything that a consumer sees and links to a particular company or university, that can be trademarked. And the only way to do that is to spend a lot of money on marketing. So it's hard to establish that link in a consumer's head. But if I see pink insulation, I don't even know the brand, but pink insulation is a famous color trademark. In the university space, shade is a big deal. I mean, if you're in the triangle, the difference between light blue and navy blue is life or death. And so small differences matter, but it's really about consistent use over time.
Just to add to that, I think in context of what you're using the colors and in location of what you're using the colors plays a role in that. And it's not specifically like East Carolina's purple is purple 268. And there have been people when we've had calls and said, well, it's the 20% rule. We're going to be close, but not exactly there. We're going to use purple 265. To your eye and my eye, just looking at it out on the street, it's the same purple. And so if you're in Greenville, if you're in eastern North Carolina, I contend if you're in Raleigh and you see light blue, dark blue, and purple, there's an association with each one of those. And so I don't think it really comes down to context, where it's used, how it's used, and I don't think it matters if it's the exact Pantone color of purple. It's this purple that's close and how it all fits together, or purple and gold, or the combination of colors of what it may be that you're looking at.
I think I have time for just one more question, so if I don't get to your questions, forgive me. Is there any legislation out on the horizon that would extend patent protection for certain categories, such as medical devices or drugs?
I'm not aware of any recent legislation, but there are there's already statutes related to what they call patent term extension, which gives you some extension related to the time that it takes you to go through regulatory process. I think it's a maximum of 5 additional years. That sort of thing is out there.
Seems like the trend is towards restricting rights and not
Absolutely.
expanding them.
I can't even imagine, well, of course, they don't do much legislating, but I can't imagine them at this point with the attitude about patent protection right now, and particularly in the area of medicine, that they would be in the process of legislating extending patent term beyond that patent term extension I just talked about.
Yeah, I believe there is some, it's not for patent protection, but for market exclusivity that came out in the Affordable Care Act. But there's a lot of specific regulations that go along with that.
Yeah.
That you really need to make sure all the boxes are checked.
Isn't there something where if you're working maybe on an orphan drug application, that there's maybe some extension?
If it's a biologic, I believe the Affordable Care Act, it was 12, but they pushed it back down to 7 years. So there are specific cases, but you really have to make sure you check all the boxes on that.
And that's for exclusivity.
Yes.
Yeah. So which that means that you can be in the market, nobody else can be in there.
Very good. Well, it's been a great conversation. I hope you all learned something from it. Let's join me in thanking our panelists for being here today. Now, if any of you missed any of our previous sessions and you're kind of interested in what was covered and maybe you might like to learn more about it, you can access those on our website, either the Office of Technology Transfer website, or you can do a Google search on Idea to Impact here at ECU, and that'll get you right to them. They're all available online. Before we go, I want to remind you that we've got some exercises we'd like to do at each of the tables. So if you're willing to stay around a little bit, we can do a little bit of practice on reviewing some different forms of projects and what kind of protection might be useful in those. I also want to remind you that in front of you, I think it's a sort of a purple half sheet of paper is a survey. If you wouldn't mind filling that out for us to give us some feedback on how we've done with this program. Pay close attention because 1 is not good, 5 is very good. Sometimes people get those twisted around a little bit. So I guess in that case, we'll just close down and go into our next sessions. I think some of our panelists will be here for a little bit, so if you'd like to talk with them or if they're able to join one of the tables, that would be great. Thank you.